Hello, everybody. Welcome to this session on intellectual property. So the idea basically of this session is to give you a sort of overview of the key things to think about. So we're going to run through the different types of intellectual property and the kind of things you want to think about when you're looking to register and protect your intellectual property rights. Before we start, though, a bit about us. So I set up the firm 14 years ago now. My background actually was in, I'd worked in two big New York law firms for about 8 to 10 years, doing sort of $500 million plus M&A, so, really big transactions. I ended up working with some, I guess in these days we would call unicorns, and really got the sort of enthusiasm startups. And so back in 2011, I quit the firm I was at and set up this firm. We're quite unique in the market because we work exclusively with startups. So a lot of our competitors do bits of startup stuff. This is 100% of what we do. It also means that I'm a happy lawyer, which is a relatively rare thing. I have a great job. I probably speak to, I don't know, 10, 12 different startups each week. Loads of different ideas come across my desk. And what I can say with absolute honesty is that it's very difficult to tell at that early stage which startups will be successful. And that's because if you want to have a successful startup, you need really 3 things. You need a business idea that can grow and scale. You need to execute it right, and you need a good dose of luck. This session is really thinking about the execution bit, so not making silly mistakes as you go through the process of getting your business up and running. So in terms of what we're going to cover, we're going to have a little bit of a think about what intellectual property is and what we're talking about, and then have a bit of a look at who owns IP and how it's transferred. We'll then look at protecting it, whether it is best or where to register IP and where to sort of build in contractual protections. We'll have a think about IP and software and how all that works, and then finish off with some thoughts about sort of priorities, dealing with infringement, and then the most important things to do and not to do when starting out. So in terms of what we mean by intellectual property, what we're talking about is all of the intangible stuff that is created in the course of setting up your business. So it's things like source code of your website, video content, images, marketing materials, maybe written content. So all of that intangible stuff is intellectual property. The really important thing, and it's going to be a theme through this presentation, the important thing to remember is that IP protection, so this is thinking about registration effectively, it attaches to the execution of an idea, not to the idea itself. So the idea is, the sort of principle here is ideas are 10 a penny. So I come along to you and say, I want to set up a business. I'm going to do a dating site for people who own pets. That may be innovative, it may not be innovative, but the reality is there's not really any IP in that, it's just an idea. Where the IP comes in is when I've got someone to build that dating website for me, I've got source code in the website, I've got the graphical representations of how things are laid out, the look and feel, I've perhaps got a logo. Those things are protectable. So the idea isn't, the execution is. And I think in terms of the way to think about IP, there's almost like 2 boxes here. Some types of IP can arise automatically, and the creator owns that intellectual property even without anything being registered. Whereas other types of IP require registration. So what I'm going to do is start with the IP that arises automatically, and then we'll move on to the stuff that needs to be registered. So the first type of IP that arises automatically is copyright. So most people, when they think about copyright, will be thinking about a book. So I wrote a book a couple of years ago, fantastic, best thing you'll ever read, you should buy it. But basically, the content of that book is my copyright. So it arose in me because I wrote it. It also arises in artistic works, musical works, but really importantly in source code. So the developer who builds your website or your app for you, he or she will own the copyright in the source code. Ownership arises automatically. So as a creator, you automatically own the copyright in a copyright work. You don't need to register it. It is possible to go away and register copyright, by the way, and there are copyright registers that allow you to do that. There's no requirement to do it. It's very much a case of You've created something, therefore you want to put a sort of mark in the sand that this is your creation. People very often do that with books, and they do it with sort of other types of copyright work, but you don't have to. The second bit of IP I wanted to talk about is not strictly intellectual property, actually, but it's sort of relevant to copyright, and it's moral rights. So when a creator creates a copyright work, they automatically get a bunch of rights that come with it. And those rights are the ones at the bottom on the screen. The most important of these is essentially the right to stop people amending a copyright work. And so we'll talk a little bit later about transferring intellectual property. It isn't enough to take a transfer of a copyright work. So you can have an IP transfer agreement. It transfers, let's say, the source code in the website from the developer to you or your business. That's important, don't get me wrong, but it isn't enough. What you need in addition is a waiver of moral rights. And if you don't have that waiver of moral rights, technically the creator of the copyright could prevent you amending the copyright work. And if you think about it in the context of source code, it'd be a nightmare. You'd have a static platform that you could never, ever amend. So it's really important to make sure you get a waiver of moral rights at the same time as a copyright transfer. Oh, we seem to have copied some extra stuff here. But anyway, the third type of unregistered intellectual property is design rights. So design rights protect the appearance, shape, configuration of a product. So you can get design rights for logos, actually, and quite often getting a design right for a logo is actually cheaper than getting a trademark. But what you have to demonstrate is that there's some artistic flair. So a design of a product, fantastic, but if it's just, I don't know, it's a technical or functional design, so let's say the layout of a microchip, you're not going to get a design right for that because there's unlikely to be artistic flair. So we're looking at something a little bit creative for a design right. Now, design rights can be unregistered and registered, and we'll talk about registered in a sec. But on an unregistered basis, the design right arises automatically and is owned by the creator once the design has been created. It grants a right to prevent copying, imports, and sales of a design, but there is a condition to it. So the product must be sold within 5 years. So you can't just get a design right for a product, register it, and expect that that is going to give you protection forevermore. You need to go and produce the product and sell it within 5 years. And the protection lasts, by the way, for a decade. So you've got a 10-year protection there for unregistered design rights. Now, in terms of registered intellectual property, the first one to think about is a design right. So you can go away and you can go to the IPO in the UK and you can register a design right. It will cost you 60 quid and it gives you 25 years of protection. So in other words, 15 years more than an unregistered design right. The process is super simple. This is genuinely one of the IP registrations that you can do yourself. It is nice and straightforward, and it's £70 from memory to register that protection. The second type of registered IP is a trademark, and this is something I suspect all of you, at least at a high level, are sort of familiar with. So a trademark gives you a monopoly right to use a brand or slogan in the course of trade in specific classifications of goods and services. So what we're doing here is we're taking a brand, so let's say McDonald's, Nike, Buckworths, we get a trademark for that, but that trademark only allows you to prevent somebody using that brand in the same or similar classifications of goods and services as your business. So if we take, let's take Nike. Actually, this is a super bad example because they're a massive brand and they've got all sorts of stuff. But let's just take Nike as an example. So they will have trademarks that cover, clothing, shoes, all those sorts of things, sports kit, all that sort of stuff. If you decided that you were going to set up a law firm and call it Nike, it's very likely that you would be able to do that. And the reason is, and I'm assuming here that Nike don't have a law firm under their name, but they have got protection for clothing and sports goods and shoes and all that sort of stuff. They don't have clothing they don't have protection for law firms. So you can go and set up a business, call it Nike as a law firm, call it Nike, and you wouldn't be infringing their trademark. So when you apply for trademarks, what you need to think about is what goods and services do you want protection for? And that's looking at what you're going to do now or in the near future, but also what you might do in a year's time or 2 years' time. So, very often you'll see restaurants, let's say, you've got a restaurant, they're going to call themselves, I don't know, Elephant. They will apply for a trademark for restaurants, but also for takeaway, perhaps for food products that they think they might be going to sell under their brand in the future. Maybe they're even going to go down merchandising. They're going to have T-shirts, hats, bags. So think a little bit broadly about this kind of stuff. Once you've applied for a trademark, and particularly when it's been granted, you can't change it. So if you want to add stuff again in the future, you need to file for another trademark. In the UK, that isn't massively expensive. Outside the UK, it is expensive. So, EU trademarks can be very expensive, US trademarks even more so. So really try to think, do a little bit of crystal ball gazing and think what you might want to do in the future. When you apply for a trademark, you apply for it in a jurisdiction. So if you apply for a UK trademark, you have that monopoly right in the UK, but you don't have it in the US or the EU or anywhere else. It is possible to apply for a trademark in almost every country in the world, but it is extraordinarily expensive. It's about, never done it, but you have to pay individual trademark fees to each regulator. And I've seen some people who've sort of calculated this. It's roughly about 50 grand to do it. Probably not a very good use of money in the early stages. So what businesses tend to do is they apply for, if you're a UK business, they apply in the UK first, and then they expand to the EU, US, other core markets as time goes by. In the UK, a trademark registration gives you a 10-year monopoly, and you can renew it at the end of the term. So you can potentially have a brand that goes on forever. And it's really, really valuable in terms of brand recognition. We'll talk in a bit about what makes sense in terms of registration and what doesn't. My view is that one of the most valuable bits of IP for most businesses is their brand. And so getting a trademark for your brand is something that is more of a priority. It's worth saying, when you start trading under a brand, even if you don't have a trademark, you do have a degree of protection. And that's based on a common law concept called passing off. And the idea basically is if somebody takes your brand, when you don't have a trademark, somebody takes your brand and they set up a business that is competing with you and looks and feels the same, if you can demonstrate that there's a reasonable prospect of customers, members of the public, being confused into thinking that their business is the same as your business, then you can go to court and you can block the use of the brand through passing off. What I would say is passing off is tricky, difficult, expensive to prove. Much, much better to have a trademark and just go after them for trademark infringement. So trademark is much better to have in place. And then the final bit of registered IP I want to just mention is a patent. So patents protect new inventions. So there's sort of three bits to this. They need to be new, there needs to be an inventive step, and it needs to be something that's capable of use in industry. So the classic things to think about here are, mechanical things. So the chappie who created the first combustion engine, I'm sure he had a patent on that. You have patents on drugs. So when people create a vaccine for a particular disease, they will get a patent for that. And what they're doing is they're getting a monopoly protection for 20 years in respect of that sort of invention that they've come up with. A really good example of this is Viagra. So Viagra was created by Pfizer. All know what it does. They got the patent for it, and they had 20 years to maximize the revenue that they could make out of that product. Once 20 years passed, everybody else could take that drug and could manufacture it. So it was about 5 or 10 years ago the patent ran out. You now have loads of different generic drugs that do exactly the same thing, but are basically, they do exactly the same thing as Viagra, but they're called something different. So, when you're looking at patents, you need to prioritize commercializing whatever it is you've got the patent for, because you've only got 20 years of monopoly. As soon as you get through that period, everyone can compete. And a really, really crucial timing point on patents is that patents will only be granted if an invention has not been displayed publicly and is not available for sale. So if you've got something that you think is patentable, you must investigate that and go down the route of patenting it before you start trading or before you tell people about that patentable invention. So what you tend to do if you've got something patentable, if you are talking to third parties about what you plan to do or what you're doing, you will get them to sign an NDA, so a confidentiality agreement, and that keeps the concept secret. One word on patents. It is possible to get a patent over particularly innovative algorithms, so software algorithms. As a commercial lawyer, my view is that whilst it is possible to get them, it doesn't necessarily make sense. Patents are expensive to apply for and expensive to maintain. And in terms of software, they're relatively easy to get around. If you think about source code, effectively it's a bunch of zeros and ones. You can code around a patent and get to a very similar place. So certainly in the UK and Europe, software patents are not particularly useful. And in my experience, investors are basically not interested. So if you're a tech business, you're a software business, think very carefully before applying for a software patent. For me, the value in patents is where you're a product business, you're doing something mechanical or biotech or medtech, something like that. That's where potentially patents make most sense. So that's the different types of IP. I'm now going to have a quick look at ownership of IP and how you transfer it. So as I've said a couple of times, intellectual property by default, in most cases, is owned by the person who creates it. So you decide you're going to get your mate Bob to create a logo for you. Bob creates that logo, you buy him a couple of beers, give him 50 quid. Bob owns that logo, not you. To transfer the copyright in that logo, you need to have a written IP transfer. And that takes two formats. It may be that you have a contract in place with Bob that sets out, perhaps he's a professional agency, sets out what he's going to do, how he's going to get paid. In that contract, there may be an IP transfer or an IP provision. What that provision should be doing is saying, from the point of creation of the intellectual property, or perhaps when you pay for it, the intellectual property is assigned to you or your business. If you don't have an agreement or the clause says something different, you may want to have a standalone IP transfer agreement. Be very careful of precedents here. IP transfer agreements are relatively standard in that the mechanics of them are relatively standard. Where we see a lot of problems is there's a bunch of precedent platforms out there that the precedent doesn't work. So what you should be worried about, because it doesn't work, is a provision that says the IP is owned by your business. That is effectively a US form. The US do things slightly differently. What you need to be looking for is a provision that says the creator assigns the intellectual property to your business. So it's that actual transfer language that's really important. Second thing around this is that usually there needs to be a flow of consideration. So consideration as a matter of law can come up in two ways. You can pay somebody to create intellectual property, a tenner, £100, £1,000, or you can execute documentation as a deed. So a deed means that everybody has a witness who witnesses their signature. A lot of VCs will prefer that there is a genuine payment of consideration rather than execution as a deed. And the reason for that is that there's a massively long line of case law about this. And there is some of that case law suggests that actually deeds are not sufficient to transfer valuable IP. So as a rule of thumb, it is better that in your agreement you say, we are going to pay you £10 or £100 in consideration for you assigning the intellectual property across. Applications for patents are dealt with a little bit differently. So if somebody creates something that is patentable for you, what you will need them to do is you will need them to apply with you for the patent. And the reason is that patents are applied for by creators. The creator has to be named on the patent. So if you've got somebody who's going to create something that may be patentable, you'll need to have some extra language in there that talks about inventions and then being a party to the invention and giving and effectively applying if you need them to for the patent on your behalf. So if you've got something patentable, a bit of extra language. Ownership of IP is massively important. If you don't own your IP, there's all sorts of bad stuff that happens. Number one, the person who created it may stop you using it. So just because Bob created the logo for me, I bought him some beers, paid him 50 quid, does not mean that I own the IP, as we've talked about. But it also means I don't necessarily have a right to use it. Bob could turn around in a year's time and say, unless you pay me 20 grand, you cannot use this intellectual property anymore. Secondly, investors may refuse to invest in your company. So with angels, a lot of angels aren't overly concerned about this. They should be, but they don't necessarily think about it. VCs are on it. So when you come to do your VC round, they will look at every single person who's created intellectual property, and they will ask for the IP transfer agreement or the provision. So it's super important to get this stuff done right at the outset. And the final point is you may actually have to pay people quite significant sums to buy the IP off them if you didn't get a transfer done in the first place. So a couple of years ago, we had a new client come to us. They're doing a big VC round. Earlier on in their business's life, one of the founders had left. No IP transfer agreement. He'd left on pretty bad terms. That founder popped up basically before the investment round and said, I own that really important bit of IP. Pay me 20 grand or your deal's not going to happen. No one wants to be in that position. So we need to put in place IP transfer provisions. What those provisions should say is the sort of bottom half of the screen. So there's an assignment or transfer of all intellectual property created by the creator prior to the date of the agreement. And that's just a recognition of the fact that often people start creating IP before we actually get down to the legal documents. So you catch the prior stuff. There's an automatic transfer of all future IP, so stuff created after the date of the agreement from the point of creation. If anything patentable comes up, or if you need to register IP, then permission to apply for registered IP in the company's name. And then two extra things. These two extra things, by the way, are not mandatory. They just potentially make life easier for you going forwards. So the first one is an undertaking that the creator will execute any further document required to transfer the intellectual property in the future. So we're thinking two things here. There are weird and wonderful circumstances that can pop up which void an IP transfer. So things around insolvency and sometimes jurisdictional issues. So it is possible, having gone through this process and got this agreement signed, for some bizarre reason, the IP doesn't properly transfer. So you then, this provision means that you can require the creator to sign another agreement in the future. The other example of this is VC lawyers. So when you're doing investment, VC lawyers, loads of different firms have different views on what should and shouldn't be in an agreement. Generally, people are pretty chilled about it as long as it, in principle, does what it's supposed to do. But every so often, you'll find a law firm who say, oh, we want it done in our standard form. Again, if that's necessary, and by the way, you would push back hard because it's a real pain in the proverbial, but if you need to get something signed, this provision gives you the stick to say you have to sign this. And the final one, which is a little bit more controversial in a way, is a power of attorney. So this is a power of attorney from the creator given to your company or to you as a director that enables you to sign further documentation in their name and on their behalf to transfer the IP. If you can get a power of attorney, and it's always worth trying to, this solves all of your problems, because if there's ever an issue in the future, you can just execute stuff under a power of attorney. But you will find some people will push back. It's not the end of the world if you can't get it. So moving on to how we protect intellectual property. And there's really sort of three bits to this. The first bit is putting in place agreements. Now, agreements are particularly good at protecting ideas. So you'll remember we said you can only, or intellectual property is only really made up of execution of ideas. And so we can only register execution of ideas and not ideas themselves. Technically, under agreements, you can protect ideas as well. So the different types of agreements that you'll be thinking of. IP transfer agreement is the one we've just been talking about. A non-disclosure agreement is effectively a confidentiality agreement. So these are quite useful where you are really early stage, you've got an idea, you think it's going to change the world, but you need to talk to people about it. You need to talk to investors, maybe. You need to talk to people who are going to build it, manufacturers, lots of different people potentially you need to talk to in order to get this thing done. So what you can do is put in place a non-disclosure agreement with them. And in layman's terms, that is saying they will keep everything confidential that you tell them, and they won't set up a competing business. They won't use any of the ideas you've given them to set up a business. One word of warning on NDAs. They are very limited in terms of enforceability. So it's highly unlikely you're going to go to a court and try to enforce an NDA. The reason for this is it's about evidence. So I say to you, I've got this groundbreaking idea of a dating website for people with dogs. How do I prove that I had that idea before you had that idea, or that it was indeed an innovative idea at all? Very, very difficult to persuade a court that that was the case. In order to have an enforceable NDA, what you are effectively going to have to do is put all of your confidential information in a schedule, because that gives the evidence that what you provided was genuinely what provided. Nobody's going to do that because it gives a blueprint for people to copy your business idea. So my view is NDAs, put them in place. They are useful. They focus people's brains, but don't assume you're going to be able to enforce it and litigate to enforce it. The final sort of agreements are non-compete provisions and restricted covenants, and these pop up in employment contracts, customer agreements, contractual agreements, license agreements. So what we're thinking about here is things like, let's take employment contracts. So you will not go and set up a competing business. You won't go to your new employer and disclose trade secrets, the cool stuff that we're doing that makes our business, valuable. You won't poach our clients, perhaps specific or in a more general sense. So those sorts of provisions can be chucked into all sorts of different agreements, and they provide a lot of protection. So that's agreements. In terms of registrations, this is really what we've talked about previously. So you're going to think about trademark protection, registration, patents, and design rights. So you may not do all of them, you may do some of them, but thinking through what registrations you want, those give you those monopoly rights for a period of time. The final sort of element of protection, which bluntly I think is sometimes the most important, is actually commercializing your business idea. The big mistake, in my view, that a lot of startups make is they are so focused on protecting their IP that they are afraid of actually trading. And I can think of clients over the past decade or so who have been terrified that people will steal their IP, and their businesses just never got off the ground because they won't tell people who can help them what they're up to. They delay and delay and delay, and somebody else comes in with the same idea or a better idea. So a big part of this is balancing protecting your idea and your intellectual property versus getting your business out there, doing stuff, having people using your product or service. You need to balance the two. Sometimes clients come to us and there's just no real IP that can be protected. So yes, they can get a trademark, but nothing else is really particularly innovative. For those businesses, it's just about getting out there and becoming recognized as the product or service provider doing what you're doing. If you could be first to market, that's massively helpful. What you want to do is get out there, launch your product, get a load of traction, get people using your products or service. If you need to raise investment, get that done quickly. The classic examples of this, Hoover, right? So Mr. Hoover, a long time ago, came up with his, sucking vacuum thing. People today still call Hoovers Hoovers, despite the fact you've got a whole bunch of different things out there. Dyson actually is a good example. A lot of people are now beginning to say, I've got a Dyson as opposed to I have a vacuum cleaner. Why? Because he's massively cornered the market. So getting out there, commercializing, getting a load of traction is actually one of the best ways of protecting your IP because it provides a blocker for people competing with you. A lot of clients ask us, where should my priorities be? Should I be registering intellectual property or should I be going for contractual protections? The answer is generally a bit of both. So registrations, as a rule of thumb, are giving you a monopoly right for a period of time. So if you think about your patent, you've got 20 years of protection there that prevents people competing with you during that period. Your trademark is giving you potentially an endless right to trade under your brand. So they give you that monopoly right. But as we've talked about, they're only applicable to executed intellectual property. So your brand, your source code, your invention, they don't cover your idea. With a registration, your intellectual property becomes public. Like the whole point of registration is you are putting all of that IP on a public register and saying, this is mine. Once stuff is public, people know what you're up to and can potentially more easily compete. So what you wouldn't want to do, as an example, is let's imagine that you have got a really cool recipe for a product. So I don't know if you, well, this is going to be controversial. Marmite, I think, delicious spread for your toast in the morning. Many people think absolutely disgusting stuff that should never have been invented. Marmite have not registered their recipe anywhere. Why? Because they don't want people to know how they do it. It's a trade secret. So supposedly Marmite have the recipe in a massively secure safe in the Marmite factory somewhere, and very few people are ever able to see it. So that's an example of where you wouldn't necessarily want your intellectual property to be registered because you'd want to keep it secret, and that's the best way of sort of protecting it. And then the final thing about registration, it's expensive. Trademarks in the UK, relatively cheap. You're talking probably a couple of £100 to get it registered, plus any sort of legal costs. Patents, massively expensive, 10, 20, 50, 100 grand sometimes. So there is a cost associated with it. And it's sort of a judgment for you as to whether you want to pay the cost or whether it makes sort of commercial sense. If we think about contractual protections, so as I said earlier, the nice thing about contracts is you can protect the idea, not just the execution. So you can have much broader protection than you would under a registration. So the kind of clauses that we're thinking about, you could say to an employee or another founder, you won't set up a competing business. A registration never gives you that right. With a registration, you're saying you can't use our intellectual property. You can't do exactly the same thing. But of course, people can compete with you. With a contractual protection, you can potentially say you won't compete. So it's a broader thing that you can get. On the other side, you can also be more targeted. So you can sort of really look at specific things. So you can say, you won't use this really specific bit of intellectual property in the course of trade, or you won't contact these specific 5 clients. So there's a bit more flex there in contracts. What you do have to be super careful of and super aware of is that there are limits to enforceability of these sorts of provisions. So as we've talked about, NDAs have limited enforceability due to evidential issues. Restricted covenants and non-compete provisions are subject to rules around restraint of trade. So currently, right now, you cannot stop an employee from earning a living. And that means that the non-competes and the restrictions you put in place need to be limited by geography and time and potentially some other stuff. So for example, if you say to a mid-level employee, so let's take me as a law firm, right? I say to my employees, you cannot go and work for another law firm, then that's just unenforceable. The courts are never, ever going to allow that. What I would have to do is say, you can't go and work for another law firm that is the same as us for a very limited period of time. And actually, quite frankly, that's probably unenforceable too, actually, because you're stopping somebody doing a job. So people like me, what I would have to do is say, you won't poach any of our clients for a period of time, or you won't use our confidential information for a period of time. Different businesses have got different sort of restrictions that apply, and it sort of depends on the nature of your market, how big it is, what sort of options people have got to get a job. One word of warning here, the Labour Party, and let's be honest, presumably the next government, have announced that they are going to restrict the period of time when non-competes can apply. And they have talked about 3 months, but there's also now subsequently been some discussion about 1 month. So you do need to, when you're putting these provisions in place, make sure there's a bit of flex. So what we're advising clients to do is say, your non-compete applies for, let's say, 6 months currently, which is for a seniorish employee probably enforceable. But we add a clause in that says if the law changes and the limit of enforceability reduces, then the 6 months is deemed reduced to the limit of the law. So restraint of trade is something to be very careful about, and it's obviously super important. And then the final point about enforceability is there's a cost. If people breach a contract, what the hell are you going to do about it? We'll talk about what you do in a sec, but in essence, you send them a bullshit letter. If they don't stop, then you're forced into some form of legal action. Where people have breached intellectual property provisions or non-compete provisions, the most effective form of legal action is to get an injunction. Injunctions are incredibly expensive to get. And bluntly, you're not going to do it because a junior employee is annoying you or former junior employee is annoying you. You're only going to do it if it's causing immediate and dramatic damage to your business because they're very expensive. So for you guys as a startup, you probably don't have 50K to blow on getting an injunction. So you need to think about the sort of the balance between having provisions in contracts that give you the right to stop people doing bad stuff and give you a stick to beat people with versus the actual cost of going through with it and enforcing. And a lot of lawyers will leverage that. So if you've got a lawyer who's acting for an employee, they may well advise the employee that you're not going to sue, and that actually they can take a bit of a view on the restrictive covenants. So sort of thinking through these points is super important to make sure that the strategy you're adopting in terms of protecting IP is the right one for you. I wanted to talk briefly about IP in software because this is an area where people get really confused and do the wrong thing, to be blunt. What we often see, and this actually comes back to precedents, we see provisions that say, and this is in a developer agreement, so you've got somebody creating an app or website for you. We see clauses that say all intellectual property in the product that's been created is transferred across to you, the client, once the invoice is paid. Sounds logical. You want to own the IP in your product. Problem is it doesn't work. And what the effect of that sort of thing in a software contract is the IP transfer agreement is basically unenforceable. It's just a waste of time. The reason for this is that within most apps and websites, there's different types of IP. And really we think about 4 main types. So the first one is what I loosely call developer IP. So developers don't create every single app or website from scratch. What they do is they take architecture for an app or website that they've created or used before. So some developers will be using other people's architecture. Most developers, particularly the bigger agencies, will use their own. So developer IP is intellectual property that belongs to the developer. And what they are doing is they are licensing that to you. They're not going to transfer it. It's a license from the developer to you to enable you to use that architecture within your app or website going forwards. You then have third-party IP. So most developers are building apps and websites on WordPress, or they're doing a no-code solution with Bubble. They're using platforms effectively to build stuff. All of the code and software that they are getting from WordPress is going or should be licensed to you. So the thing to check here, the developer will almost certainly have a license, but once they deliver the website or app to you, you need a license as well. So the question you should be asking your developer is, how am I able to use this? Do I have a license to use it? And you need to make sure that you do. There's then open source software. So open source licenses are basically licenses that grant rights to use source code from a sort of open source community. And they apply to most of or lots and lots of common stuff that's available on the internet. So if you think about, you have a website and it has some scrolling functionality, almost certainly that's open source. Why? For obvious reasons, we don't want developers to recreate every single thing from scratch. We want them to take stuff that people have done before. There's a really vitally important point about open source licenses. They come in two, or very simplistically, in two different formats: copyleft licenses and permissive licenses. Copyleft licenses can be problematic. So what they can mean is that any improvement or development of the code subject to the license itself is open source and is subject to the copyleft license. So what you can find is you've pulled, or your developer has pulled a bit of open source source code onto your platform, and they could theoretically have therefore made the entire platform subject to that copyleft license. That's a huge problem because your investors will want you to own IP and they'll want you to have a monopoly right on that IP. So as a rule of thumb, we want to avoid copyleft licenses. Permissive licenses are licenses that don't do that, though sometimes you will have to acknowledge the license that you've used in your T's and C's. So it's worth understanding the permissive licenses that have been used. With open source licenses, therefore, there's two things you're thinking about. One, you need to know which licenses have been used, and you want your developer to give you a list of them because you're going to need to disclose it to investors and acquirers in the future. And number two, you need to make sure that you're complying with the rules of the license. So you don't want copyleft, and you need to understand if you have an obligation to disclose that you're using the license in your T's and C's. So all of those bits of IP that we have talked about, you're getting a license of the IP. You are not owning that source code. The only source code that you are going to own is the source code that has been built on a bespoke basis for you by the developer. And this is sometimes a lot of source code, sometimes a little bit of source code, but this is what is being transferred or assigned to you. So you can immediately see, if we think about our original IP transfer agreement that said all the IP in the website that you're building for us is transferred to us on completion, that's garbage. It isn't. Most of it's licensed. What you need to make sure is that those licenses are set out and that you have an assignment or transfer of the bespoke bit. So in terms of priorities and timelines, I think in terms of priorities, you need to think of it from the perspective of you want to own as much intellectual property as you can. So think about your business, think where the IP sort of arises, and make sure that you own it. As a rule of thumb, that means getting everybody who creates intellectual property to sign an IP transfer agreement. And it's massively important that you get founders to do it. The biggest cause of problems that we find is founders quit for whatever reason, and they haven't signed an IP transfer agreement, and you then have to persuade them to sign one. If you fired them or they're upset or pissed off, that's a really hard thing to do. So get founders to sign IP transfer agreements from the get-go and avoid potential problems down the line. Basically, think of it like a prenup before you get married. We're going into a marriage, everything's going to be fantastic, but let's be honest, we get a prenup done so that just in case we've married a psycho, we know what the position is going to be. Think about whether anything is patentable as soon as you can, and whether it makes sense to get a patent. So the stuff that we talked about, remembering that once you've got a product or service out there, it's public, you're not going to be able to get a patent of it. And in my view, start generating revenue as soon as you can. Don't delay things because you're scared of people nicking your idea. Think about whether you want to do registrations and contractual agreements, get that stuff nailed, and then go for it and get revenue generation. In terms of sort of timeline, similar sorts of things. So before anything is made public, you need to think about whether you want a patent and whether it makes sense. If you do want to apply for a patent, you need to have gone through that process. Think about whether particularly your brands is likely to infringe other people's IP. So one of the awful things that happens too often, to be frank, Clients come to us when they've launched their business. They've spent loads of money developing their branding, marketing, all this kind of stuff, and they come to us to do the trademark. We do a trademark search, and basically there's a ton of identical or very, very similar trademarks in their space. As soon as they apply for a trademark, they're going to get an opposition, they're going to be potentially taken to a tribunal, and they could be sued for damages. So before picking a brand, you need to do basic searches. Check the trademark registers or get a lawyer to do it for you. Have a look at social media, have a look at URLs and domains, do a Google search. If you're finding stuff or finding people doing a similar sort of thing as you with the same or a similar brand, you need to talk to a lawyer and either, well, talk to a lawyer and figure out whether it's viable or not, or just change the brand and do something different. With that in mind, think about getting a trademark around about when you start trading. You don't need a trademark, you're protected by passing off, but it's so much easier to stop people infringing your brand if you have a trademark. It's much cheaper and much quicker and much easier. So it's not number one priority, but it is something to think about around about when you're sort of commencing trade. And I would say review your IP transfer agreements every so often, quarterly, ideally, but probably a bit too much. What we just need to check is that all of your team members have signed IP transfer provisions. The biggest thing that we see, you know, people have got IP clauses in employment contracts and they've got them in contractual agreements, and, you know, they get interns to sign them. But the reality is people, for whatever reason, don't sign the employment contract, or they forget to chase the signature, or the intern doesn't sign. We come to an investment round and we've got people who are important who haven't signed the right documentation. So just keep track of it, check it every so often to make sure that you've done everything you need to do. In terms of infringement, it's going to happen to most of you at some point. I think there's a couple of sort of practical points to think about. The first one is, if you think somebody is infringing your intellectual property, don't jump the gun. You need to check the facts, understand who is infringing, what they're infringing, and what the legal arguments are that support your position. I would say 50% of the clients who come to us because somebody is infringing their intellectual property, the reality is they aren't. They've set up a competing business, and there's nothing wrong with that. People are perfectly entitled to look at your website and go, that's a good idea, I'm going to do the same thing. What they can't do is do it under the same brand, and they can't sort of nick the content on your website. Setting up a competing business is generally fine. So you need to take a step back and make sure that you have actually genuinely got an argument. If you have, then the next step is generally sending a cease and desist letter, or more likely an infringement letter, that is basically saying you're infringing our IP, you are required to stop immediately, sign undertakings confirming that you won't do it again, and potentially pay our legal costs or damages. As a rule of thumb, good idea to get a lawyer to do that. It has a lot more effect than you doing it yourself. If that still doesn't work, most of the time, by the way, it does actually, but if that still doesn't work, with registered IP, so trademarks, patents, design rights, you can then go to the tribunal, which is run by the Intellectual Property Office, make a tribunal claim, and commence a relatively straightforward sort of process with them. Relatively cost effective, relatively straightforward, and relatively quick. So that's one of the benefits actually of registered IP. You can also, at the same time or in the alternative, start a court process. And normally, if you're doing that, you'll be applying for an injunction, which is basically preventing somebody from continuing doing the stuff that is damaging you, and or applying for damages. With unregistered IP, you're almost certainly going to be commencing a court process. So more expensive, more tricky, but you know, still a viable option if you've got unregistered IP. One thing I just wanted to mention actually was what happens if you've got somebody infringing your website, or nicking your or scraping content from your website and using it on their own website. What you can do is you can actually go to the website and hosting providers. So for every website on the internet, you can go to a who is search, Just Google who it's searched and it will give you the link. It will tell you, in an ideal world, who the owner of the website is, but more likely who the registrar is. All the registrars have a mechanism to make a complaint with them. Most of the UK and European ones will now push you through a process with WIPO, which is the World Intellectual Property Office. And basically what you do is you put a complaint into WIPO, demonstrate that this is infringing your trademark or some other intellectual property rights. And WIPO will fairly quickly block the website if on the face of it looks like they are infringing your IP. And then there's a sort of a process, a tribunal process that goes with it. But absolutely worthwhile doing. There is a cost associated with it, but it's not massively expensive. In terms of what not to forget, please don't start litigation or threaten to commence litigation without coherent legal arguments that are supported by evidence. It is actually an offence to do it. Lawyers, sometimes we can take a view on this. There are ways that we frame things when we're not 100% convinced of the merits. But even lawyers, we have to be a little bit careful. You shouldn't just go chucking out threats and accusations if you've got no basis whatsoever for your claims. It's an extremely bad idea. So yeah, think very carefully about that. Remember that a competitor copying a business idea may not involve IP infringement. It may be upsetting, it may be damaging, and it's definitely worth speaking to a lawyer about it, but it may not actually involve IP infringement. And the sort of final point on this, you want to try to be proactive rather than reactive. So it's much better to have got registrations in place, to have put contractual provisions into agreements with your employees, contractors, customers, and be able to discourage people from infringing IP rather than go, we're not going to bother with any of that stuff. We'll deal with the infringement if and when it happens. For some contractual stuff, sometimes that makes sense. For intellectual property, it's generally absolutely the wrong way of doing it. So get that protection in place, and that should hopefully reduce the risk of infringement. And if you do have infringement, it will make it much easier for you to protect yourself. Last slide then, before we go on to questions. Top tips to avoid problems. So these are a list of things that pop up every so often, and I think that are easy enough to do. So you mustn't use unlicensed images from the internet. When you set up your website, it's very easy to Google a picture, think that looks cute, pop it on your website. If you do it, at some point, you're going to get a really nasty fine against you. Images on websites have got little bits of data in them that identify who owns them. If you take the image and you put it onto your own website, that data stays with it. And the picture agencies like Getty, they have little robots that track the internet. They find that little bit of information and they pop you a litigation letter and say you owe us 1,500 quid or £3 grand. Very difficult to defend against those claims. Not impossible, but difficult and generally not worthwhile. So don't use unlicensed images. Every startup in the world, frankly, copies logos of people and puts them on their website. So it will say things like supported by a bunch of universities, Google, Apple, or it will say our customers include all of these different brands. Just be warned, if you don't have permission from the business's logo that you are using, you are infringing their trademark. There's no defense to that, by the way. You're infringing their trademark. So I'm not saying strictly don't do it, but just be aware that you shouldn't be doing it without permission. If any of those businesses come back to you and say, remove our trademark, you do it immediately. And generally they will, but just sort of be aware of that one. Obvious stuff, don't copy other people's sort of content or layouts. It's their intellectual property, build it yourself. Search the trademark registries before choosing a brand, as we talked about. Register a trademark sooner rather than later. Make sure everyone signed an IP transfer agreement. Address IP infringement promptly when you spot it, ideally using lawyers, because it is much more effective. And ensure that contractual restrictions are actually enforceable. So, you know, don't go putting in non-compete provisions that say people can't compete with your business for 100 years, or provisions with employees that say you can't work for a competitor for 20 years. They're just never going to be enforceable. So you need to sort of balance enforceability with giving the protection that you need. So that is all from me. We do all sorts of stuff, IP, but also a load of other things. We spend a huge amount of our time doing investment rounds, lots of money around at the moment, by the way, as well as all of the other things on the screen. If anybody has any questions, I think Ivan will run through them.
Yes, absolutely. Thanks so much for that insightful presentation, Michael. I hope that everyone found it helpful. Guys, we have quite a lot of questions, but I'm mindful of the time, so I'm just going to pick on a few. And the first question is from Oli. Can we apply for a trademark ourselves, or do we need a lawyer?
Yeah, that's a good question. You can apply for a trademark yourself. So there's a sort of relatively straightforward system on the IPO's website that allows you to do it. The only word of warning on this would be the fact you've been granted a trademark doesn't mean that trademark is enforceable. So we find quite often that people will apply for a trademark, they'll get it granted, it will be infringed, and then the trademark registry will say, well, actually, your trademark's not enforceable. Trademark law is complicated. Our advice would be get a lawyer to help you with it, to make sure that you've maximized the enforceability of it. The other side of this is that very often when you apply for a trademark, you're going to get letters from the IPO that say, for example, we think there are competing trademarks. A lot of people then panic and withdraw the trademark. Lawyers will tell you you don't need to do that. You can generally either proceed with the registration or make some amendments to it. So yeah, you can do it yourself. Better to get a lawyer to help.
Perfect. Thank you, Mike. Next question is from Tilly. How do I protect my idea?
So I think this is what we've been talking about. You can't get a registration for an idea. So really it's about contractual protections, and it's probably the NDA. That's probably sort of the most common way of trying to protect yourself. Yeah.
Perfect, thanks. I'm just going to take two extra questions. The next question is from anonymous attendee. My co-founder is leaving and refuses to sign an IP transfer agreement. What do I do in this scenario?
Yeah, a tricky one. Your options are a bit limited. I mean, in an ideal world, you want to try and persuade him to sign an IP transfer agreement. You may have bits of leverage there, so you may be able to, I don't know if you can attack his shares, perhaps take some shares back, or perhaps pay him some money to sign it. The other approach is if you can identify what intellectual property is created and it's not particularly important, you can potentially stop using it. So if you can say that he's created this bit of this bit of source code, you can potentially just recode it, get somebody to redo it and take his intellectual property out. It's not ideal, but if push comes to shove, that they may be your only options.
Perfect. Thank you, Mike. And final question from Stefan. Please comment on copyright and generative AI content. Who really owns the content? AI content.
Yeah, it's an interesting one. It's a complex answer, that one. So I guess two bits to it. The AI engines that you use. So if you're using a ChatGPT or something similar, they have different licenses. Their free license, I think anything you create belongs to ChatGPT or OpenAI. But their enterprise licenses, I think anything that you create belongs to you. So some of it is governed by the licenses of the platforms that you're using. There's a secondary point, which is around whether there is any protectable intellectual property in content created by AI. This is currently subject to litigation, by the way. But what the courts so far have said is that if an AI engine has created content, you can't get an IP protection for that content. There is no IP in it because intellectual property itself needs some human intervention. So it needs some artistic flair to allow IP to develop in it. So there's a practical question about whether AI content is capable of having intellectual property in it. The courts are open on this, and the view was that government was going to have to legislate to come to a view on it. I think with the general election, God knows if that's going to happen or not. But I think there's going to need to be legislation on this going forward. In practical terms, you're not going to apply for a patent for AI-driven content because it doesn't qualify. For copyright, technically it needs artistic flair. What you can potentially do is you can let an AI engine generate some copyright, and then you can potentially amend it further, thereby giving you that sort of authorship of the content. But yeah, it's a good question and a complex one in practice.
Perfect. Thank you so much for your time, Michael. Thank you for everyone again for joining us at our Lunch and Learn webinar. In terms of next steps, our next event is on 18th of June. It's on employment law essentials for startups. It's at 11 o'clock, and Michael will be covering everything that you need to know as a startup in respect of employment law. It will cover all the documents that you are required and agreements with your employees. We currently have about 15 tickets remaining, so make sure that you go and book them before they are sold out. In respect of Michael's book, Built on Rock, Michael published the book 2 years ago. It was a bestseller on Amazon. It's basically a legal guide that covers everything that a startup needs to know in order to drive its business to success. Currently, we are running a special promotion on the book. It's discounted with £5. It's until the end of the month, the promotion, so feel free to go and grab it, or you can always go on our website and download chapter 1 for free. And we are very, very active on social media. Feel free to follow us on Instagram, Facebook, LinkedIn, and Twitter. We write lots of articles and blogs in respect of anything legally related to startups. So check our insights page on the website. And probably in the next few days, the webinar will be published on our website and our YouTube channel. So if you want to review any of the information from Michael today or reflect on it, you can get on our website again. Thank you so much for joining us, and we look forward to seeing you at our next event.
Thanks, guys. Bye-bye.